my name is Rachel Snyder, as Heidi said. I work here at Stafford Rosenbaum. I'm primarily a member of our trust and estates team. I also do work with a lot of nonprofit organizations, and I do a little bit of election and political law work and government work. So my practice is a little varied. And for many of you, you might know my mentor, Johanna Alex. I work with her very closely, and I know she has quite a strong connection with Groundswell, and our firm does as well, and we're hoping to maintain that. So let's get going today. So for the presentation today, we're going to cover several things, including why and when to get started with estate planning. I'm going to go over some fundamental concepts that will hopefully lay the stage for the rest of the discussion, help everybody understand what estate planning really is. We're going to talk a little bit about why and how to include charitable giving as part of your plan, if that's something you're interested in doing. I've got a few tips at the end for how to get started with the process, if that's something you decide you'd like to do. And then a little bit of information about what you should be able to expect from the estate planning process, whether you work with us or you end up working with other attorneys. We're happy to work with you, but there's lots of great options for legal counsel in the Madison-Dane County area. So what is estate planning? Well, I like to start off by saying estate planning is for everyone. It's not just for people that have significant wealth. It's not just for people who want to worry about distributing their property. Estate planning is about managing transitions, and it's primarily addressing two different points in time. So the first is that while you are still living, but you are unable to manage your health care for yourself, or you're unable to manage your financial affairs for yourself, that usually arises for folks when they're facing some sort of disability or incapacity. The second point in time that estate planning addresses is property distribution after your death. So it's important that you think about estate planning in that sort of holistic framework and realize that when to start really is as soon as you're able, as soon as you can get up the gumption to do it. We recommend you do it now, because you never know what's going to happen, and especially to the extent that it addresses the need for agents while you're living, the sooner you get that sorted out, the better. So you might ask me, why do I need an estate plan? Doesn't state law control what happens by default? And yes, it does in part, but not completely. And you may not like exactly how state law would control your property distribution and some of the decisions that need to be made about your health and finances while you're living. And so a way to take control of the situation is to put together an estate plan. So if we start with some fundamental concepts, like I said, there's a couple of basic terms I want to go over with you to lay some groundwork, and this will help you evaluate what tools would be available to you to create your estate plan. Because estate plans have a lot of common elements, but rarely are they identical from one person to the next. And you can think about the tools that are available to make yours unique to your specific needs. So starting off with the term probate, we've probably all heard that term before, but what does it mean? Really, it's the court supervised process for determining whether a will is valid and for ensuring that property is distributed according to the terms of the will. A probate case is opened in the county where someone was residing when they pass away, and it starts by the filing of bunch of paperwork. There's a petition that gets filed. Important to the discussion is what we'll really focus on later, but not everyone needs a probate case, and some people really want to avoid it for a variety of reasons. But we can deal with all of that with your estate plan. So big picture, probate starts with filing paperwork. And then the court appoints a personal representative. That's the term Wisconsin uses for executor. So if you think executor instead of personal representative, it's okay. It's the same thing. It's just Wisconsin uses the term personal representative. You can name a person in your will to fill that role. And unless there's some kind of objection to the person you've named serving, the court's generally going to go along with that. Then there will be a period of time after the probate is initiated for creditors to file claims. So if you had any outstanding bills, there's about a 3.5-month time period wherein people who might claim that your estate owes them can file a claim with the court. There has to be notice published in newspapers to let possible creditors know. If your personal representative is aware that you do have any particular bills that are owed, they might notify those creditors directly. And then after that 3.5-month period, generally speaking with some limitations, then if somebody hasn't filed a claim, they're foreclosed from doing so. From there, your personal representative is responsible for pulling together an inventory of your whole estate, all of your property that is subject to probate. That gets filed with the court. It's generally due about 6 months after the probate case is opened. Then the personal representative takes care of paying everything that needs to be paid, pays all the bills, sells any property that needs to be sold, and ultimately prepares a final account of your estate that shows all the money that was there when you passed away, and then how the money was distributed. So then the court can sort of review it all and say, yes, this was done in accordance with the terms of the will. We're good, we're gonna close it out. So altogether, a probate typically takes about a year. We can ask for extensions if we need, but courts don't like that, so we try to avoid it if we can. Another big term in Wisconsin estate planning is marital property. So marital property is a classification system that does apply by default if you are a resident of the state of Wisconsin and you're married, but it's a system that can be modified by agreement. And I know we've got some folks in the room that spend a lot of time outside of Wisconsin. For anybody that was married outside of Wisconsin, marital property classification might apply to you if the state you were in before had marital property. It definitely applies once you move here to property that you acquire from the point that you establish residency here moving forward. It is also possible to, so for any property that may have been considered individual before, it's possible in Wisconsin to commingle assets in a way where property that was individual becomes marital. So all of that matters because it speaks to whether or not you as an individual can control entirely how your property is distributed when you pass away. Generally speaking, with marital property, spouses have a 50-50 interest in everything that you acquire during the marriage, no matter how it's titled. So maybe you buy a house and it's titled in the name of one spouse, but it's 50-50, both of yours. Which also means that if one spouse passes away, that spouse can only control what happens with half of that property, unless we enter into a marital property agreement that reclassifies the property in some way. Now, there's different reasons why you may or may not want to do that, but that's sort of the big picture of marital property. So what's a will? A lot of estate plans, the center of a lot of estate plans is a will, and that's probably what we think about most commonly. Generally speaking, a will is a legal document that coordinates distribution of your real and personal property that is, as I said, subject to probate at death. In Wisconsin, a will must be in writing, and the testator, the person who is creating the will, must sign it in the presence of two disinterested witnesses. We also take the sort of best practice step here, and I think most attorneys do, of making sure that not only is it witnessed by two people, but also notarized by a third. So don't be surprised if when you go to sign your estate plan, There are 3 people in the room. One of them's a notary. Ultimately, the will controls tangible personal property, so things like jewelry, your furniture in your house, your clothing. It will control any specific gifts that you want to make of those items. And it controls distributions to your residual beneficiaries. So you might say that you want a certain amount of cash to go to certain people or certain charities, and then anything that's left over goes to X. So anything that's left over is generally called the residue of your estate. And you can say who that goes to without having to specifically say, identify necessarily each item that you own. So do you need a will? Maybe. My general recommendation is yes, you should at least have a will. But to start figuring out whether that's really true for your circumstances, you need to think about what property you have. So do an evaluation. Figure out what you have that is subject to probate and that isn't. So what you have that would be subject to probate are all of the things that don't have titles, or things that are titled only in your name. So if you happen to be a single person and you own a bunch of things and it's titled only in one name, because you're a single person, not married, that's the type of property that's subject to probate. So jewelry, books, furniture. Property that isn't subject to probate are things that are controlled by beneficiary designations or some other contractual provision. So life insurance pays out to a beneficiary, that's not subject to probate. Retirement accounts that you put a beneficiary designation on. Any bank account that you have a payable on death or a transfer on death designation on, yep.
What's POD mean?
Payable on death.
Oh.
So if you go to the bank and you say, hey, I have this savings account and I want to put a beneficiary on it, usually a bank will tell you, oh, for us, that's called a POD, payable on death to whomever you name. And if you own property with survivorship rights, so a lot of times married couples will own real estate as husband and wife as survivorship marital property. So automatically, when one spouse passes away, that spouse's half interest in the property is automatically transferred and becomes the property of the surviving spouse. So if you have a mix of probate and non-probate property, which most people do, and you want to control what happens to the distribution, you should have a will. It's also important to think about how marital property plays into this. So as we talked about before, Wisconsin law presumes that all property acquired during marriage is marital, but you can vary that by agreement. We call it a postnuptial marital property agreement. If you're doing it for estate planning purposes with one attorney, it will not speak to what happens if you happen to get divorced. If you want a kind of marital property agreement that addresses what happens at divorce, your attorney is going to tell you you guys each need separate legal counsel because you're technically potentially adverse to each other, and that would be a conflict. But with your marital property agreement, for estate planning purposes only, spouses can agree that certain property is individual, can dictate by will then how that property gets distributed. And at least in Wisconsin, not all states, but in Wisconsin, you can use a marital property agreement as sort of a backup method to distribute property to someone else outside of probate. So if you really don't want that probate case open, state law here recognizes that you can put into a marital property agreement language that says, I want these pieces of property to go to so-and-so. Usually people name their spouse outside of probate. And at least in Wisconsin, those are to be honored. You might run into some issues with financial institutions that get, especially national financial institutions that are very concerned about legal liability, and they might just tell you they're not going to honor it. So we don't recommend a marital property agreement alone as a method to avoid probate. but it might be included in your plan as a backup. So, advantages of putting together a will. It allows you to think about the beneficiaries in your life and their individual characteristics, their unique circumstances and needs. It allows you to give things to charity. So if you let the default rules apply, which I'll probably mention again later, the default rules don't allow for giving to charities. As we've said before, you're able to appoint someone that you trust to serve as the personal representative of your estate. And commonly in wills, you can name a guardian. You can say, that that's typically for any minor children you might have. And then you can sort of build the structure for distribution of your assets that you want. I did get a question before today that was talking about how to identify professionals to fill the role of personal representative or executor. There are banks that would fill that role. A lot of banks have trust divisions that have individuals who can fill that role. There are also like standalone trust companies that can fill that role. The biggest thing I think is making sure that you are comfortable with the institution and the people that might serve. So if you're interested in naming a professional, I recommend you make an appointment and have a conversation with those folks. Ask about the fees that they would impose because they don't do it for free. And then ask about whether they require you to give over management of your assets, because some do. I know US Bank, for example, doesn't serve in the role of trustee or personal representative unless all of your assets are given over to them to manage. I know there's at least one trust company in Wisconsin. They do have an office here in Madison. It's called Fiduciary Partners Trust Company. We work with them a lot when our clients don't want to give over management of assets. They like their financial advisor. They want to keep their financial advisor. Fiduciary Partners doesn't manage any assets. So those I think are the important questions to ask. Those same institutions are likely to be willing to serve as trustee of a trust if you set one up, and potentially to serve as a professional financial agent under your financial power of attorney. So worth asking if they would fill all of those roles. Yep.
I have a question here. The question is, if I have property that is titled in the name of 3 people, myself and my 2 parents being, and the other 2 people are Florida residents, what happens if one of us passes?
Well, if it's with those 3 people, then I would guess without seeing the deed that you probably own it as tenants in common. And that means that the 3 of you each have an individual 1/3 interest in the property. So when you pass away, let's say you pass away and your parents are still living, your 1/3 can be controlled by your estate plan. So then it would just depend. Or if there's some other kind of beneficiary designation that you put on the property, which is possible, depending on which state the property is located in. We sometimes record what are called transfer on death deeds associated with real estate here in Wisconsin. And it's like putting a beneficiary designation on the real property, where you can say it goes to so-and-so upon the death of such owner. You could do that to set it up to say it goes to the other owners. Your share would be split 50-50 among the living owners.
So properties in Wisconsin.
Yep, so.
No one else is on the deed title and there are no arrangements currently.
Right, so the default should be that you own it then as tenants in common because you're not married. So you can control your 1/3 with your estate plan, and the other owners would need to control their 1/3 with their estate plans, or you need to enter into some kind of an agreement between the owners or among all of the owners. For example, a buyback agreement, you could say, that when you die, the other 2 will purchase your interest from the estate. And then, so there's several different ways to handle it, but if there's just a deed and 3 people on it that are not spouses, It should be tenants in common and you can control your 1/3.
It says, if one of them passes, I'm assuming their third would go to the spouse.
Depends. I don't think so. Not under the deed. They might have their own estate plan that says that's what happens, or if they don't have an estate plan, the Florida rules of intestate succession might kick in and say, yes, all property to spouse if there's no will saying otherwise. So it's possible, but I can't say that for sure without seeing the deed and knowing more about the situation.
And I have another question.
Mhm.
Would you like to take that now, or?
Yeah, sure.
Yeah, he says, my wife and I set up a revocable trust. Should we retitle our home so it is in the name of the trust rather than our individual names?
Good question. Let me get to it in a slide or two, because I do want to talk about trusts. So I'll just go over this one last slide here about wills. So do you need one? I'm gonna tell you, yes, likely. It's a good idea to have one. Primarily because it allows you to control things that the default rules don't allow for. So this comes up a lot for people that have second marriages, especially people who have children from a prior relationship. You can plan for them. You can plan for grandchildren, and make sure that charities receive distributions if that's what you want. You can make distributions that aren't equal. So the default rules, which we'll talk about in more detail, to the extent that they control distribution, they require generally equal distribution at generational levels. You can get around all of that and do something unique. You can also control whether, like, let's say you have some fairly young beneficiaries, even with just a will, you can require that any inheritance a young beneficiary would receive be held back in some kind of a custodial account or a trust for them until they reach a certain age when you feel comfortable that they can manage whatever you're leaving to them. So really, it's important to think about your unique life circumstances and whether you want something other than the default. And if the answer is, yeah, you do, then yes, you need a will. So what's a trust? So let's get into talking about trust. Because commonly estate plans will also be centered around a trust. There are a number of kinds of trusts out there. You might hear lots of acronyms. Generally speaking, a trust is it's a contract between whoever is establishing the trust. The language is often used as grantor or settler, and the person who's authorized to manage it, the trustee. And it's a contract. It sets forth all kinds of the powers of the trustee, duties of the trustee, and like a will, would designate how all of your properties to be distributed while you're living, but also after you pass away. So for most people, we set up revocable living trusts as the primary type of trust that you would have. And in Wisconsin, because of marital property, it's not uncommon for us to have joint revocable living trusts for spouses. And we're going to focus on that type of trust for our conversation today. So why would you perhaps want a trust? Well, for some people, they're useful tools for tax planning. Generally speaking, that's for very, very high net worth individuals. Right now, you have to have, as an individual, over $12 million in your estate for tax planning to really matter. As a couple, that doubles. So if you're married, it's over $24 million right now, before the estate tax at the federal level kicks in. That is going to change, unless Congress does something about it. That sunsets, and I believe in 2026, it comes back down to 5 million per person. That's still a lot. So it'd be 10 million-ish for a couple. It's a lot for a lot of folks. That's certainly not where I am in life, but who knows? Maybe you've lived a very fruitful life and that matters to you. So you might want a trust for tax planning reasons, but if you're not in that boat, you may still want a trust for other reasons. For example, you can use a trust to avoid probate. You might want to avoid probate because probate is not private. That's something very important to a lot of people that inventory of your estate that gets filed that I mentioned and the accounting, those become public documents. Anybody can ask for them. For most people, I don't think it's likely that anyone's gonna go to court and, ask for your will and all of those things. But they can, and for some people, that is something they wanna avoid. Especially if there's, some weird family dynamic. You can avoid that altogether by putting everything in a trust and having all of your property administered through your trust outside of probate. With a revocable trust, you typically are set up to serve as your own trustee. So it'll look strange when you set it up, but it is a contract between you as the grantor or settlor and you as the trustee. During life, it uses your own social security number for tax purposes. You don't have to do anything different with your taxes. You still file the 1040 like you're used to doing. And you have complete control over your assets. You can buy, you can sell, you can do whatever you want. It's a little bit more costly upfront for the reason that gets to the question that was asked, because part of the process of making sure that a trust does what you want it to do is retitling assets or putting beneficiary designations on everything to make sure things go to your trust after you pass away. So with respect to real estate, should you retitle it in the name of your trust? You should either do that or record a transfer on death deed that says that your property will transfer to your trust after the second of the couple passes away. You need to do one of those two things. I don't know that one is better than the other unless you have a preference for how that plays out. You can still sell property that's retitled in the name of the trust. You just do it as the trustee. And the title company might ask for a little more information from you, like a couple of the pages from your trust to verify that it exists and that you are the trustee and have the authority to act. But yes, you should do something with your real estate. Otherwise, after the second of you passes away, if it's not in your trust already or automatically moved there, then a probate is going to be necessary to deal with that asset. So, disadvantages of a trust. Well, it can be cumbersome, especially in the beginning, because you might have quite a lot of assets, financial assets, real property. You might have property inside Wisconsin, outside of Wisconsin. You need to take an inventory of what you have and make sure that everything is either titled in the name of your trust or will go there. You put in place the mechanism for sending it there. And speaking of learning curve, you have to keep it in mind for the rest of your life. If your primary goal is to avoid probate, you need to keep it in mind as you acquire and sell assets for the remainder of your life. Because as I said, if things are not properly titled, then probate might still be required, and that could undermine your entire goal. So what happens under Wisconsin law if you don't have a will or a trust? Then the laws of what we call intestate succession apply. The state statutes say who receives your property in what order. So generally speaking, your property would pass to members of your family. The first person to receive from you is a spouse, if you're married and your spouse is living. Property then would go, if you're not married or your spouse is not living, when you pass away, then it goes to any children you may have in equal shares to those children. If you have no children, then it goes to parents. If your parents have predeceased you, it goes to your siblings or to their kids. If you don't have any living people in that sort of generational group, then it goes back up to your grandparents. And if they're not living, down your grandparents' lineal line, so potentially to aunts, uncles, cousins, but it stops there. So if down your grandparents' line of descendants, there is no one, and then it would escheat to the state. So you go to the Department of Revenue, and actually the Department of Revenue uses anything that escheats to it to help fund what's called the Common School Fund. So in the end, your assets would help pay for public school libraries, which you might not be upset about, but that could always change. And you might want to control what happens to your assets instead of just letting default apply. And it might sound crazy, but it matters. I can tell you, I did work on a probate in the last couple of years for a man who died in his 90s. He had no will. He tried, but he wrote it on some paper and it wasn't properly witnessed. It didn't count. He had no spouse, no kids, no parents, no siblings. So default rules had to kick in, and we ultimately spent tens of thousands of dollars on air searches, newspaper publications to try to find people who would be his default beneficiaries, legal fees. There were over 150 heirs identified for his estate. And ultimately then people received assets, but some only a couple $100. And that's really, I would put money on that was not what he wanted. So important to think about. And as I said, intestate succession doesn't allow for giving to charities. It doesn't allow for unequal distributions. If you have someone in your life that has special needs and you want to care for them in some way, you can't do that without setting up a will or a trust. And you can't point to the person you want to be your executor if you don't have a will or a trust. So then if we think about estate planning holistically, like I advised from the beginning, you also have to think about who you would want to name to manage your financial affairs while you're alive, but can't handle them for yourself or don't want to. So that's key with the financial power of attorney. The document is authorization that you give to someone else to act on your behalf with respect to all of your financial affairs. That kind of document can be drafted to go into effect immediately, or it can be what's called springing. Now, for some people, immediate makes sense, especially as we age, you might want help. Did you have a question? No? Okay. No, that's fine. You might want help with managing some of your financial life before you're actually considered incapacitated. So in that circumstance, you might want it to go into effect immediately. Alternatively, if you're not comfortable with that, you can set it up to say it goes into effect only after you've been deemed incapacitated, which would require 2 doctors or a doctor and a psychiatrist to evaluate you, to say, yep, you are not able to handle your financial affairs. That standard can be altered slightly. You can't alter it with your healthcare POA, but if you prefer, if you have a particular position that you would want to weigh in on that, we could say, you know, that it's incapacity is determined not based on that person's evaluation of you. But regardless, you want to think about who you want to name and have this as part of your estate plan. You can also really control what kind of authority your financial agent has. So we do use sort of a standard template that covers sort of the gambit of financial issues that we're aware of. And there is a state default form that a lot of people use as a template, but you can alter the powers. You can make it broad, you can make it more limited. So there's a lot of things you can do with financial POA based on your comfort level. If you end up in a situation where you are incapacitated and you can't handle your financial affairs on your own and someone needs to step in, if you don't have the POA, then the person who's trying to take care of the situation for you would need to go to court and be named the guardian of your estate. Similarly, if you have health issues and you end up in a place where you can't make health decisions for yourself, it's important to have a power of attorney for health care. Like the financial POA, you're naming someone to act as your agent to make healthcare decisions on your behalf. This is a kind of document that, at least under state law, really only goes into effect when you're deemed incapacitated. And that's a standard that we can't change. That's when 2 physicians and a physician, or a physician and a psychiatrist, have to evaluate you, determine you're incapacitated, and then activate the form. Healthcare POAs, you can also, there's questions in a healthcare POA that you need to answer about how much authority you want to grant to your agent. And it's also something that, your agent is bound by. So it's important to choose someone that you trust and someone that you're comfortable having conversations with about your healthcare wishes, because they are legally supposed to consult with you if they still can. Likewise, any healthcare providers you're working with are supposed to consult with you, and if you're capable of expressing a wish, they're meant to follow it. But it's important to know that you've spoken with someone you trust who can answer those questions the healthcare providers might have when you can't answer them yourself. Along with your healthcare POA, there are 2 other documents that we typically put together for people if they decide they want them. You might hear the term living will. It's also called declaration to physicians in Wisconsin anyway. That's a document between you and your healthcare provider, no agent in between. And it allows you to make specific choices about whether you want certain life-sustaining procedures withheld or withdrawn from you if your death is imminent. And then the last one is called a HIPAA release, sort of colloquially, also known as the healthcare information release. It's a standalone form because it allows you to name people that your healthcare providers can talk to without worrying about HIPAA regulations. And that might be a broader group of people than you would be comfortable naming as your agent. So let's say you've got 3 kids, maybe you only want one of them named as your healthcare agent, but you'd be okay with all 3 of them talking to your doctor and getting information. You can use your HIPAA release for that. So I think I need to speed up here. I'm looking at the clock, right? So should you consider charitable giving? Well, yes, I think you should consider it. Obviously, whether you do it is ultimately up to you. But it does have some benefits, many of which are non-financial, and these are very personal reasons why you may choose to consider gifting to charity. Obviously, there's the concept of paying it forward. If you've had a fruitful life and you want to pass that good fortune along to others, giving to charity is a way to do it. For many people, it provides emotional uplift. It does encourage community. And a lot of charities really, really need it. So that might be something to encourage you to give. Aside from just sort of non-financial motivators, it also allows you to take an income tax deduction if you give during your lifetime. And if you give through your estate plan, your estate can take a charitable deduction, which again, really matters if the estate tax applies. So for a lot of people, it doesn't matter. But if it does matter, it can be quite significant. There's a lot of ways you can give during your lifetime. It's one way to give appreciated assets without realizing capital gains tax. So you can give stock, you can give real estate, things that have appreciated in value, and that if you sold them and then gave the money to a charity, you would have to pay the tax first and then give the remaining proceeds. If you can gift the appreciated asset to a charity and not realize capital gain at all, and then the tax exempt charity also doesn't have to pay the income tax on that. Big caveat though, make sure you talk to the charity first. Not every organization is set up to accept appreciated assets, especially real estate. I have worked with organizations in the past that have had to just disclaim a gift of real estate because it didn't work for their mission. They weren't set up to deal with it. And although the decedent really meant well and wanted to support the organization, a conversation in advance before death that would feed into how that will looked would have made a charitable goal actually, be fulfilled instead of what ultimately happened, which was no gift was made. The other thing that you can do if you're in a situation where you're withdrawing assets from your retirement accounts, especially if you have to make required minimum distributions every year, you can direct that those go to charity instead of receiving them yourself. And that's a way to make sure, it's a way to avoid tax. So what ends up happening is if you roll over your RMD to a charity, that income never comes to you. So you don't realize any of that income and don't have to pay tax on it. And neither does the charity. You can also gift through giving life insurance. You can name charities as beneficiaries of your life insurance policies. You can name them as beneficiaries of tax deferred retirement benefits, and you can just give property. Again, I would just say, please check with the charity, because they may advise you that they can't accept what you want to give. They also may weigh in on the language of the gifting instruments, that it actually works for them. So sort of big picture, think about your estate plan as a whole. And think about whether each piece of it works with all of the others. It is very possible to undermine your entire plan if things aren't coordinated. It's also very important that when we're talking about the pieces of your plan that exist while you're living are what you want them to be, that you've named agents trust, that you've named agents that can work together if you've named more than one person to fill different roles. You don't have to, you can name one person to fill all of the various roles, but a lot of times people will spread that work out for different reasons. Make sure they can communicate with each other effectively. Make sure that your trust, if you have one, is fully funded. All of the beneficiary designations have been updated appropriately, or assets have been retitled. And then think about whether you want to write a letter of last instruction. Not everyone does. Actually, in my experience, people rarely do, at least with us. They might do it later and I never know about it, but you can write a letter that talks about your wishes for sort of this, like the intent behind your estate plan. Also express your wishes for any last burial services, or any wishes you have about how your body and property are disposed of. If you do that, make sure it's kept with the rest of your estate planning documents, and that your various agents know where to find them if they need to find them. Should you review your estate plan periodically? Yes. The rule of thumb is typically 3 to 5 years. Just at least take a look at it. Make sure that it's still what you want it to be. A lot of times goals change, life circumstances change. You know, you put together a estate plan when your kids are in elementary school, and look at it again when they're in high school or in college, and your life's totally different. And maybe now you trust them, they're adults, and they can be your agents. You would want them instead of whoever you named before. Maybe you have grandkids now and you want to provide for them, and they aren't accounted for in the first version of the will that you have. So good idea to just check in, take a look at it, see if you want to make any changes. Also, the law changes. The law changes over time, and sometimes that means your estate plan needs to be updated to account for it. Ultimately, what can happen to you if you don't update it? If you have a life change that impacts your estate plan, your wishes may not be fulfilled. So if you have powers of attorney documents, for example, that name people that are no longer living or no longer able to serve in those positions, and then you need that, somebody has to go to court and be named your guardian. If you pass away while you have minor children and you didn't name a guardian, or you did name a guardian, but that person's not around anymore, somebody's gonna have to go to court and be named guardian. Maybe you bought something and you didn't think about your trust. If you sit down in a review, especially if you review with some professionals in your life, tax advisor, attorney, whomever, you might identify some of those assets that are left outside of your trust, and that's the time to make sure they get into your trust where you need them to be. So good idea to review periodically. So to get started, know that how old your plan is, know where it is if you can find it, if you have one at all. Put together an inventory of your assets and how things are to be distributed right now. Think about who you would want to name to fill all of the different positions that we've talked about today. Think about whether your plans for asset distribution have changed. And think about whether you've got any family issues now that need to be accounted for. And what should you be able to expect if you reach out for legal help with this, you should receive a call back from an attorney or at least from the attorney's office within a short period of time. I would say probably within a few days. You will likely be asked to provide the attorney with specific information, especially if you are working with someone new, or working with a new firm, because they're gonna have to run a conflicts check and make sure they can represent you. You should ask about fees. You might not get like a locked in rate. For example, we really don't do flat fee here, and that was one of the questions I received in advance. But you should be able to get a picture from legal counsel about what you can expect in terms of cost. And then you should receive drafts for your review well before they need to be finalized, so that you can take a look at them, you can weigh in, and you can ask for specific edits if you need them. And make sure that you feel comfortable with whoever it is that you've hired to work with, because you should be able to give feedback without repercussion. It should be welcomed, because how we practice matters, and we only know how we're doing if you tell us how we're doing. So, to answer that question about fees, if you were to work with us here, generally speaking, a plan that is wheel-based, doesn't have a trust, is typically somewhere in the range of $1,500 to $2,000. If you want the trust, and then we help with all of the extra paperwork that goes along with that, it's typically between $2,000 and $2,500. All of the attorneys here do charge hourly.
Anyway, so I told Doug,
So I guess that takes us here to any additional questions. Does anybody have anything you'd like to ask?
Are there any questions online, Ben, at all?
We have a hand raised. Are we fine with unmuting
Yeah,
mics now?
absolutely.
You can unmute your mic if you like. Or if you'd like to put it in the chat as well.
Yeah, so if anybody wanted to ask a question now and just speak to me, that's fine. You can unmute your microphone and just ask.
Maggie, Dr. do you guys have any questions?
We were interested in like appointing executives because we don't have kids.
Mhm.
And just, you kind of answered that with, going to banks and making appointments and talking
Or
about
trust
that. So, the trust companies. It was very interesting to find that some of them require you to, I can't remember what you said, but basically turn over
Management of assets. Yep,
Which we would not want.
We would not want to do that, no.
right.
We like our.
So if I were in your shoes, then I would go for smaller, like regional banks. I wouldn't, like, don't go to US Bank. I already know. But you could check in if you work with, I think it's called Lake Ridge Bank now, which is a
Okay.
combo of Monona Bank and Bank of Cross Plains and one other. It was three banks recently merged. I don't know if they require management of assets, but it wouldn't surprise me if they don't, just because they're smaller. And like I definitely just from personal experience recommend Fiduciary Partners Trust Company, and I can give you the name and
Okay.
contact information if
Great,
you'd like.
that'd be good, yeah.
We have one question here that says, what are your tips for encouraging family members, aging parents, to start working on a will, making the process less scary for them?
Good question. I would show them this PowerPoint presentation. So, let them watch something like this, and hopefully I'm not intimidating, so they can see not all attorneys are. And maybe periodically drop some hints about what the default rules mean. If you know your parents have certain wishes, and based on listening to this today, that those wishes wouldn't be fulfilled without an estate plan, it's worth sort of hinting that that's the only way to get around the default rules is to put together some kind of plan. The other thing is to let them know that if something happens and they are hospitalized, and there's no power of attorney, if it's not an emergency situation, the hospital's likely to require that somebody go to court and be named guardian before they start accepting decisions from that person. I don't know that your parents want to force you to go be named guardian. So sort of, I think, talking about the potential consequences of not having one, but in a nice way, might be effective. And like I said, I do recommend, I mean, maybe looking at somebody like me is not gonna be appealing to your parents. Maybe they'd rather talk with a peer. I think that Johanna did this presentation last time and that her presentation is still online. Are you planning to replace?
Nope, that was still, it would still be online as well.
Okay, so if you think they'd be more comfortable with someone who is a little closer to them in age than I would be, Johanna is older, not gonna say she's old. She might watch this presentation, but she's older than I am.
Careful.
And, so maybe show them that one. Maybe they'd be more comfortable with someone like Johanna.
One question that I had gotten before this presentation by someone was saying, I don't think they were necessarily, and I think I mentioned this to you, they weren't necessarily concerned that someone was going to contest their will if they made one, but they just wanted to know, like, can you go in reliably with a pretty decent amount of assurance that your will then is going to be upheld? And
Right, well, I mean, the only way you can know that somebody's not getting contested is you know your family. And, I mean, you can protect yourself from a will being sort of thrown out by making sure it's properly executed. So that's where I'm saying not only witnessed by two people, but also witnessed and notarized by a third person. That's why it's best practice among estate planning attorneys to do that instead of just the two witnesses. And make sure that you destroy old wills and so that there's no conflict among documents. So if you change your mind about assets and how they're distributed, you know, which is perfectly fine, you might update things several times over the course of your life, destroy the old ones so that people aren't trying to submit conflicting wills to say one is valid and the other isn't. And maybe consider writing a letter of last instruction, especially if you have sort of asset distribution that is going to be controversial to some folks. Let's say you don't have a good relationship with one of your kids and you're intentionally not leaving them anything. I would write down why. And maybe even have that as part of your plan and witnessed and notarized. Because at the end of the day, if there's a will contest, witnesses will be called. Your attorney might be called. The person who drafted your document could be called to testify about your state of mind. And so if you're concerned at all about contest, work with reputable legal counsel. Don't try to draft it on your own so that you have assurance that it was properly executed and that you have witnesses that would be deemed credible who could speak to your wishes after you're gone. Yep,
So we have wills, they're out of date.
sure.
We had, the first wills we made up were done by an attorney in Houston.
Mhm.
Second wills by another attorney in Texas.
Yep.
In terms of destroying old wills, should we notify their offices that those wills are no longer in effect and to purge them from their
That's a good
files?
question. If they've retained your
We
documents.
have no idea.
Yeah, I mean, so for us here at Stafford, for example, we don't keep your originals. Unless circumstances are very unique, but our practice is to make sure that clients go home with the original documents and a full copy. We keep electronic versions, for at least 10 years, it might be longer, but, so you could check in with those attorneys and just ask whether they have any of your originals and that, you know, give
It
permission
seems
to
like it's
destroy
not
them,
would
but
hurt, just
it doesn't
to,
hurt.
just to say,
You
we've
don't
got new
have to.
wills, okay.
You don't have to, but it doesn't hurt. I would say anything you have, get rid of the old
Yes.
stuff. Because if your personal rep, your, you know, executor is taking stock of everything, they're gonna be looking for those documents, and if they can't find them because you don't have them, are they gonna know to go to some attorney in Texas to find out whether you have an old document? Not if they have one in their hands that's relatively current and they have no reason to look for another one. Yeah, so I think we've reached time. So I think we're gonna wrap up. We'll remind everybody that this is, this was recorded and you will all get a link. Thank you.